Okay, we're on. First up, I want to handle the matter of Terrell Johnson. And I've got a phone number here for Ms. Parrish. And is that Ms. Parrish that's on the screen there? It is?
It is? Yes.
Oh, okay, good. Then I don't have to call her. Wonderful. Can I have everyone who is on this file, please identify yourselves for the record?
Pete Roder.
Lou Roder.
It's the current guardians.
Okay.
Roder, do you need the spellings?
No.
Okay, I'm sorry, go ahead.
Alexandria Fedewa, DHHS.
Jennifer Sikatowicz, DHHS.
Okay, so we're here on a motion to terminate the juvenile guardianship. I'm assuming you folks still believe that it's necessary for it to be terminated?
Yes, that's correct.
All right, what's the agency's position on this and where do we go from here?
Your Honor, Terrell is currently living in Ohio with his sister Kendra. He was there in a safety plan of sorts, safety plan of sorts while we were waiting for this hearing. He's in agreement with living with his sister and desperately wants a connection with his family. He was attending school here in Michigan and he was employed here in Michigan, and they are working, Kendra needs legal documents to get him enrolled in school down in Ohio. So we were just waiting for the decision today to be able to get that to happen. Background checks could not be run on her due to being out of state, but from what we could access through public records, there wasn't any concerning information. For example, I checked the sex offender registry in Ohio and there's nobody registered at that address. And the information that we have out of the Michigan systems, there's no information on our end either in terms of Miss Kendra Parrish.
And you believe currently then what is in the best interest of Terrell is that the current guardianship be terminated and that Kendra Parrish be appointed the guardian?
That is correct. Yes, that is correct.
Obviously, this would not be a subsidized guardianship, is it currently?
No.
All right. And Ms. Parrish, this is something that you are in support of?
Yes.
Do you have any concerns about your ability to care for and manage Terrell? Obviously, he's created some issues with his last two guardianships, last two guardians. Are you familiar with what the issues are? Are they things that you think you can handle?
Yeah, I'm familiar with the entire situation. I have no objections to him being with me at all.
All right, well, based upon the report and recommendation from DHHS, I am going to grant the motion to terminate. I'm going to appoint Ms. Parrish as the successor juvenile guardian. There's some paperwork that we're going to need to generate before that's actually going to take place, but we'll try to get that prepared and out to you just as quickly as we can.
Your Honor, before you stop this case, Ms. Parrish has called the clerk's office and me several times, so you might want to let her know this is the time for her to ask questions. She's called about schooling, numerous things.
Did Ms. Parrish, did you have questions for the court?
Like I said, my only thing is I need some type of legal documentation to make sure he gets into school, because he has been out of school since he got here, and I just don't want him missing. He's already missed basically a month of school and don't need him missing anymore. Really.
Well,
That's my only
The
issue.
paperwork that's going to be generated as a result of this hearing today will provide you with all of the authorization you need to get him into school and to get anything else that he needs. You will be in essentially the position of a parent.
Okay.
I want to make sure I've got a current address. I'm not seeing anything in any of the paperwork that I currently have. Ms. Fedaway, is that something you could please email to Shannon?
Yes, yes, I can. I will.
All right. Any other questions?
No, sir.
No.
All right, I am going to grant the motion. We'll get the paperwork out just as quickly as we can. Thank you.
Thank you.
Thank you.
Thank you.
All right, next I want to handle the matter of Christian Belden. And I'm letting Lisa Belden into the courtroom. She had signed in after we had started the proceedings today.
Yeah, and Christian's there with her.
Oh, okay. Hello, Christian.
We're here. Hi.
So Shannon, can the rest of you please identify yourselves for the record?
Molly Wagner, DHHS.
Chelsea Wells, psychologist.
John Kane, I'm Christian's attorney.
Okay, let me ask you first, Mr. Kane, what is your recommendation for appointment of a guardian for Christian? Do you believe it to be in her best interest?
Yes, Your Honor, I've spoken with Christian about it. She is in agreement, reviewed Ms. Wells' report. And although we will be going through that in more detail, her conclusion appears to be that it's in Christian's best interest to have a guardian. And we'll go through the details of that after the testimony.
Very well. So, Ms. Wells, could you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Would you state your full name for the record?
Chelsea K. Wells.
Mr. Kane, are you prepared to examine the witness this morning?
Yes, Your Honor.
Go ahead.
Thank you. Your Honor, could you, sorry, Ms. Wells, could you state your occupation and credentials for the record as well?
Yeah, Master of Arts, a psychologist. At the time of the evaluation, I was a temporary limited license psychologist. I'm now a limited license psychologist, and I am under the supervision of Dr. Brent Smith at Arbor Hills Psychological Services.
Good. And you know Christian Belden?
Yes, I do. I met with her on February 24th, 2020.
You performed a psychological evaluation on her to evaluate the guardian and determine her ability to make informed decisions. Is that correct?
That is correct.
As part of that interview you just mentioned, did you interview anyone else?
I did. Lisa Belden, Christian's mother, was also present.
And you prepared a written report with the results of your testing, your diagnosis, and your opinion evaluation. Is that correct?
That's correct.
Has your diagnosis or opinion changed from what you've stated in the report?
No, it has not.
Are there other changes that you feel need to be made to the report?
No.
And what tests did you perform as part of your evaluation?
So I completed the Wechsler Abbreviated Scale of Intelligence, second edition with Christian. And those scores indicate that she had a full scale IQ composite score of 86, which falls in the low average range. And that's comprised of a verbal comprehension score of 89 and a perceptual reasoning score of 87, both of which fall in the low average range. I also had Lakeisha Thompson, who was the transition coordinator from Vista Maria, complete an adaptive behavior assessment on Christian. And her scores indicated an overall general adaptive composite score of 70, which is falling in the extremely low range. And this is comprised of a conceptual score of 74, which is in the low range, a social composite score of 82, which falls in the below average range, and a practical score, which also falls in the extremely low range. So her scores indicated severe deficits in regards to Christian's adaptive functioning. And I also had Lisa Belden fill out the same form, but at the time, Miss Belden Christian had not lived with her mother in over 2 years, so she was basing her results on when she was living in the home. Her overall score was a 69, which fell in the extremely low range. Conceptual composite score of 74, which is in the low range. Social composite score of 80, which fell in the below average range, and a practical score of 66, which fell in the extremely low range. And the last assessment that I administered to Christian was a memory assessment, which she scored a 24 out of 30, which fell in the normal limits of cognitive functioning.
Thank you. Did you reach a diagnosis as a result of your testing and observation?
I did. Christian has a diagnosis of autism spectrum disorder.
Is there a more specific designation within that autism spectrum disorder diagnosis?
In what regards?
Well, I'm looking at your report, and there's a reference to F84.0 as well.
I'm sorry, I didn't hear what you said.
Is the F84 designation part of that diagnosis? Does it designate a spot on the spectrum? What is the significance of that notation?
So that's just the overall code for autism spectrum disorder. So she does have a below average cognitive functioning, but she struggles in the social aspect of things and communication skills.
And is her current condition something that manifested itself prior to her turning 18?
Yes.
Do you anticipate this condition to continue indefinitely?
Yes.
All right, so based on your testing and observation, as you know, I need to ask you about substantial functional limitations in 8 areas. So we'll just go through the first is does she have substantial functional limitations in the area of self-direction?
Yes.
Self-care?
Yes.
Mobility, getting transport around town kind of thing, not just walking?
Yes.
Her capacity for independent living?
Yes.
What about the area of learning?
Yes.
Receptive and expressive language?
Yes.
Economic self-sufficiency, handling money, making change, etc.
Yes.
Can she hold a job?
She has held employment in the past. She reported to me that she did have employment at Kroger at one time. When I met with her in February, she was not employed, but was thinking about it in the future. I think she would need strict supervision in any type of employment that she holds. So she would definitely need supports in that area.
Okay, thank you. Does she have substantial functional limitations in her ability to speak with doctors or understand what a doctor might discuss with her?
Yes.
Is she able to participate in or make decisions regarding her medical care, treatment, and placement?
I believe she is, but she needs assistance in those areas.
Does she have substantial functional limitations in handling legal affairs?
Yes.
All right, so she is currently, she just moved. She's living in, I believe, a group home in Jackson now.
Okay.
Vista Maria, when you looked, examined her, evaluated her, have you had a chance to evaluate her current living arrangement?
I have not. Like you said, when I met with her, she was still at Vista Maria, but they were planning on moving her closer. So I'm glad that that happened. I do think that's the most appropriate placement for her right now.
Very good. And you recommend that a plenary guardian be appointed in your report. Is that still your opinion and recommendation today?
Yes, it is.
Thank you, Ms. Wells. Your Honor, that's all I have for now.
So I'm looking at the order, Mr. Kane, and some of the boxes I've got to check here. Specifically, I don't know if you have the standard order in front of you, but number 7.
I don't, Your Honor.
So, I'm required today to make a decision as to whether Christian is totally or partially without capacity to care for her person or estate, as to the following necessary tasks, responsibilities, or judgments, but is otherwise legally competent and has the capacity to perform in other areas. I want to make sure that's fully developed.
Okay. You have questions you wanted to direct to Ms. Wells or me to pursue these things?
Well, I can certainly question her. You testified that there were some areas in which Christian was able to function but needed assistance, correct?
Yes.
What are the areas where she has some limited ability to function?
So I know in regard to medication management, that was always been a struggle for her. When she was living at her parents' home, she refused to take medication, which is attributed to some of the escalating violent behaviors in the home. So as far as remembering to take medications on her home, understanding what the medications are for, I think there are some difficulties in that area. She's proven that she has held an employment in the past, but admitted to not being able to manage her money appropriately. She had reported to me at the time that she struggles with saving money, but she spends it if it's available. So being able to manage that money if she does hold employment will be a struggle for her as well.
Do you believe the most appropriate and least restrictive living arrangement for her, given her condition, is living in an adult group foster home?
Based on when I met with her back in February, that seemed to be the conclusive decision based on my conversation with Christian, based on my conversation with her mother, that would be the most appropriate placement because there was structure involved there.
And do you happen to know the name of the current group foster care home that she's in, or do I get that from Ms. Wagner?
So it's not considered a group foster home. It's a large home that has like rooms that are rented. I believe it has a living room area, a kitchen area that's shared, and then people have their own rooms. And then she has a worker from Tenacious Living coming to her to help her with whatever she needs every day.
All right, so she's not currently living in something that would be referred to as a facility, correct?
No, it's a home that's her rent is being paid to a landlord.
Okay, so has Christian expressed her preference for who she would have serve as her guardian? Mr. Kane?
Yes, Your Honor, my understanding is she does want her mother to be appointed guardian request, but she is present here and able to clarify that if you like.
Christian, do you wish to have your mother serve as your guardian?
Yes.
Mr. Kane, is any further record required today in order for me to rule on this petition?
I don't believe so. The only other issue that normally I would address in a situation like this is, as a plenary guardian, I don't believe Kristen has sufficient assets to require that the guardianship of the estate be implemented. I would suggest that that be suspended, granted but suspended, so that accountings are not necessary. But were she to come into some funds through inheritance or some other means, she wouldn't have to go through another evaluation to have those powers.
And it is your recommendation that a plenary guardian be appointed?
Yes, Your Honor. Based on the report of Ms. Wells, that was her professional conclusion. I have no basis to dispute it.
All right, and Ms. Wagner, you're in support of appointment of a guardian, specifically Ms. Belden, on Christian's behalf?
Yes.
Very well. Based upon the testimony, I do find that there's clear and convincing evidence today that Christian is an individual with a developmental disability and requires guardianship services. I will be appointing Ms. Belden as the plenary guardian of the individual. State powers suspended until there's sufficient assets that would require that those powers be extended. All right, is there anything else the court needs to address this morning?
I would just ask that Christian's foster care case be closed. She was supposed to have court on the 6th for a review hearing.
We'll take care of that. Based upon the appointment of a guardian, there's no need for the foster care case to remain open.
Okay, thank you.
Your Honor, would it be
thank you all.
Your Honor, would it be appropriate to submit my invoice to the county?
Yes, I am going to provide in the order that attorney fees are to be paid by the county because there are insufficient funds in the estate.
Thank you, Your Honor.
Thank you.
Thank you.
That concludes our hearing. You're welcome. Take care, Christian.
Okay.
Bye.
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 Okay, next up. Norma J. Kelly Estate and Revocable Trust. Julie, would you approach? Okay, counsel, state your appearances, please.
Good morning, Your Honor. I'm Stephen Rick here on behalf of petitioners and beneficiaries Chris Farhad and Amy Kennedy. He's on mute.
Try that again. Good morning, Your Honor. Corey McCord on behalf of the respondent, Anthony M. Kelly.
All right, and Mr. Rick, these are your motions.
Thank you, Your Honor. We've filed two different matters before the court here. One is a petition to reopen the estate and with objection to the sworn statement to close. The reason we want to reopen the estate is that there were assets in the estate, primarily an IRA, that we believe, and I think the court has indicated its opinion that it agrees, were inappropriately accessed by Mr. Kelly before Norma Kelly's death. And so we weren't made aware that the estate was being closed. We did file objections to the estate accounting, and the court has had hearings on that. So I know that Mr. McCord is new in the case. He indicated we had not filed objections to the estate accounting, but we did. And so those were well before the court.
I was confused as I was reading the motion and the response. So the final accounting was served and objections to that were filed, but the sworn statement to close was never served on the other, not on yourself and not on any of the beneficiaries.
That's correct, Your Honor. You know, I get a lot of paper flowing through my office, and so I checked as best I could. I don't remember getting one, and I did not find one. And then I checked the court file, and there was no proof of service in the court file that it had been served on me. So my best memory is I did not receive
The first time you remember seeing that was when Mr. Rapley filed it in a brief in the trust file.
I'm not sure I've actually seen the sworn statement other than the court file, but the first I learned of it was when Mr. Rapley filed a document that indicated the estate had been closed.
He referenced it, okay. All right, I'm with you then, thank you.
So I do believe the estate should be reopened, frankly, whether or not the sworn statement or the certificate of completion should be set aside, I guess doesn't matter. You know, we've petitioned for the estate to be reopened, and so we do ask that it be reopened for the purpose of the court rendering an opinion on the issue of breach of fiduciary duty and in particular the IRA assets. So I'm willing to submit it on that particular petition. I want to address these separately.
Yes, let's do that. Let me hear from Mr. McCord on the petition to reopen.
Thank you, Your Honor. As Mr. Rick said, I'm new to this file. Obviously, this file is quite large. I didn't anticipate it being as large as it was when I agreed to take the case on. So in certain ways, I'm at a little bit of a disadvantage. But in other ways, I get the opportunity to Monday morning quarterback a little bit, which is always the easiest job. When I look at this, it looks like a sworn statement to close was filed July 25th, 2019. The probate court issued a certificate of completion on September 6th, 2019. I agree with Mr. Rick that there is no proof of service in the court file. There did not appear to be a proof of service in any of the files that I got from Mr. Rapley when I took this case over. Mr. Rapley indicated
But let me stop you for just a minute. The certificate of completion, is that something that's typically issued to all interested parties, or does only the personal representative get that certificate?
In my experience, I think it just goes to the personal representative. Now, when I do these probate estates, I always send a copy of that to all the interested persons, so there's no dispute. But in this case, it went solely to my client, the respondent, and I do not see a proof of service showing that that was ever sent out to anybody either. I'm not sure that sending that out is required, but I always do it as a matter of course. I prefer to send more than I need to than not enough.
Certainly, yeah, because that was my question, is even if they didn't get the sworn statement to close, if they got the certificate of completion, that would trigger, wait a minute, we need to object to this. We need to do something.
Right. And Mr. Rapley's indicated that he sent both of those out, but I don't see proofs of service in the file or in my personal file or in the court file. So I think Mr. Rick is correct on that. Whether or not they were actually sent, whether or not Mr. Rick got them, I don't know.
So hold on, let me stop you for just a minute. So Mr. Rick, I heard you say that there's no sworn statement to close anywhere in your files, and no indication that you got it, and no memory that you got it.
That's correct.
Is that also true of the certificate of completion?
Yes, Your Honor.
All right. Wanted to make sure we were clear on that. Go ahead, Mr. McCord.
Thanks. October 24th, 2019, Mr. Rick filed a petition to set aside the certificate of completion. As far as I can tell, based on my review of the file, And if I'm wrong, either one of you, please correct me, because I know that both of you spent a lot more time on this file than I have. That petition, there was never a formal response filed, and the court never ruled on it. And then we go to I think you folks had the evidentiary hearing in April. Maybe, let me check the date on that. Sometime this year, you have an evidentiary hearing where all of those issues basically get flushed out. I guess my big complaint, if you will, is I feel like things are kind of done out of order. Like I said, it's always easy to Monday morning quarterback it. So the sworn statement to close and certificate of completion were never set aside. This estate was never formally reopened. There's a hearing on the estate. The court issues a very lengthy, detailed opinion in May that was advisory as to these issues, and then allows Mr. Rick to file an amended petition. I guess my concern is I sort of compare that to getting the answers to the exam the day before and then taking the exam. When the hearing was held, the certificate of completion and the sworn statement to close were still in effect. The estate was never opened. And I suspect ultimately that, based on my conversations with Mr. Rapley, Mr. Kelly, and Mr. Rick, that folks here, there's a lot of tension, a lot of bad blood. I suspect folks here are probably going to the Court of Appeals no matter what happens. So I guess that's my big issue is we've already had a hearing on a petition, and it's already, I guess, kind of the horse is already out of the barn on that. We already know what the court's thinking. The court, I know her testimony and did a hearing. I don't have a transcript of that hearing. Mr. Rapley apparently didn't have one of those. I am going to attempt to get one of those at some point. Obviously, we'll need that.
I think there is one, isn't there?
Yes.
There should be one in the file.
Okay. So, and that's something I do want to see ultimately. That's the only thing it looks like he didn't have. So I guess those are my issues on that. So we're going to reopen this estate, even though we've already basically had a hearing on it and sort of had an off the record ruling on it. It just seems out of order to me on this one.
Well, if I can respond, Your Honor.
Go ahead, Mr. Rick.
I believe there may be some misunderstanding as to dates. There's been no hearing on this matter in 2020. Hearings were in previous years, and the evidentiary hearing was in 2019. The petition to set aside the certificate of completion was in October of 2019, after all the hearings. So I guess I'm not sure that Mr. McCord has the sequence of events correct. I believe there were proceedings, and I'm going to say that we were before this court 10 times during the course of the 3 years or so we've been involved in this. Culminated in an evidentiary hearing, and 1 or 2 hearings after that. I think the court had all the information it needed to make a ruling on the estate, except that the estate apparently had been closed. So there may be some question about the order. Again, I'll just say what I said before. Let me say one other thing. A certificate of completion, if you'll read it, just says that it appears the personal representative has completed the required duties. It doesn't really close the estate in the sense that the personal representative no longer has authority to act. They have authority to act for a full year after the estate has a certificate of completion. Ms. Kelly can correct me on that if she likes, but I see she's nodding her head. And so, what we're asking here is that the estate be formally reopened, and we believe there are grounds to do that because we didn't receive notice of a sworn statement being filed or received a certificate of completion, and there were still issues before the court that needed to be addressed relating to the estate. So, on that basis, we do a petition, a request to reopen the estate.
So, Mr. McCord, the evidentiary hearings that were held, the proceedings that have been held to date have all been in the trust. The petitioners raised several issues relating to breaches of fiduciary duties, and In response to that, the trustee's attorney, Mr. Rapley, objected to the court considering any alleged breaches of fiduciary duty that occurred prior to the, while being the personal representative and while serving as a fiduciary under a power of attorney that all predated the trust proceedings. So the issue, that's why it happened the way that it did. It was in front of me based upon the trust administration, and then these other things were discovered in the course of that litigation. They were raised, an objection was made, and I agreed with Mr. Rapley. I can't make those kind of a decisions in the administration of the trust. Those acts or omissions occurred during the administration of the estate. And once I finally did issue an opinion, that's what I said. It appears that there's valid theories and basis for a claim for a breach of fiduciary duties that have been asserted, but I couldn't really rule on them without the estate being open. So here we are.
Understood. That made it a little more clear. Thank you.
And if I just want to add one thing to that, Your Honor, I mean, there was a lot of testimony that related to the estate. In fact, there were orders issued by the court relating to the estate. We had some disputes early on in the proceedings regarding access to the IRA, which was the only estate asset. And so proceedings have been ongoing with respect to the estate throughout. It's just that the court didn't feel like breach of fiduciary duty had been alleged. And so that we're reopening it to include an allegation of that effect. And
all right, well, based on what I've heard on this issue, I'm going to grant the petition to reopen the estate. It was still my hope that by signaling before we went down that road, my view of the facts as they were presented as they related to transactions occurring during the administration of the estate and earlier, actually, that would perhaps lead to some conversation towards resolving this case. One of the real roadblocks to resolving the case when it first came to me was an absence of funds with which to negotiate. And apparently now there's at least assets from the sale of the house that are being held and can be used at least as a basis to try to negotiate some relief.
Right.
I realize your desire, Mr. McCord, is that you at least be given an opportunity to try to facilitate a resolution. Mr. Rick, you were expressing some doubt as to whether or not that was likely. I would hope that with Mr. McCord's involvement and his optimism that at least should be explored, that it should be explored. We're gonna open. I don't know how much more is going to be incurred in attorney fees, but or how far away a resolution is. But it strikes me that a resolution through facilitation is far more likely to result in a speedy resolution of this case if there's going to be one.
And that was my thought, Your Honor. I just, coming in last minute, talking to Mr. Kelly, going through the file, talking to Mr. Rapley, you know, and once the court makes final rulings, I know part of the opinion was just advisory. I suspect one or both of these folks are going to Lansing, and it's the cost that they will incur to do that. I figured facilitative mediation of some type is worth a shot. But again, I'm pretty new to the file. Mr. Kelly, my client, Anthony Kelly, was open to the idea. And I guess, yeah, maybe I'm a little optimistic, but again, I haven't been involved in this case for 3 years either, so.
Well, certainly the advantage of facilitation is it results in a full and final resolution. A ruling by me is likely to result in an appeal by one party or the other.
Yes, well, you're right, Your Honor. I'm not optimistic that facilitation will help. And just to briefly comment on that, the primary issue, according to my conversation with Mr. Rapley, was strictly the pre-death activities. I think we were essentially in agreement with regard to the accounting, other than the $120,000 that the court found had been wrongfully taken by Mr. Kelly from the IRA and the trust. And so my understanding is that Anthony Kelly is pretty much immovable on that issue. He is not willing to negotiate at all with respect to whether or not he owes additional funds from before death. I mean, if there's some indication that there's a likelihood of some movement on that, maybe facilitation will help. But I can tell you my clients are willing to move a little bit, but I don't hear anything from Mr. Kelly on that.
Well, I certainly understand why he was unwilling to negotiate that before I issued my opinion. My hope was that he realized once I issued my opinion that there was definitely some exposure there, and that that would be rethought.
Perhaps with new counsel, we'll make some ground on that, Your Honor.
I think it's worth a shot. I'm a firm believer in facilitation. I get it that there are times when one or the other party is completely intransigent, and I'm reluctant to order facilitation if either party is being totally intransigent. I mean, but you can figure that out pretty quickly in a facilitation. A good facilitator will find out in a hurry. And if the parties are just miles apart and neither one's willing to make any kind of a session, the facilitation usually ends within a couple of hours. I think it's worth a shot. I'm assuming you haven't talked about a facilitator?
No, we've not.
I mean, quite frankly, I've been involved a few weeks and I spent most of this time. Mr. Rick was kind enough to give me an adjournment. I spent most of the time just going through this nearly foot tall file. So, but I'm open to, I'm open to it. I think Mr. Kelly's open to it. We did talk about that at length, based on the advisory opinion, based on just the costs involved, when this goes the other way. I mean, the court's already indicated this is what I think. It just seems like it might be worth a few hours worth of time to see if things can get resolved. And Mr. Rick has been involved in this file a long time. Perhaps he's right in this, it won't last long, but I thought it was worth at least the chance. But
I'm not even supposed to make a recommendation for a facilitator, but there is a gentleman up the street who I've had a lot of experience with over the years. He's pretty busy, but if you can get in to see him, if anybody is capable of bringing about a resolution, he would be. And you probably know who I'm talking about.
I think I do, Your Honor.
that's who I was thinking too, but I'm open to whoever, but that was my initial thought.
And I don't know how far out he's scheduling things, but I'm going to direct that the parties participate in facilitation by a facilitator that you mutually agree on. If you're unable to agree on one, I will appoint one. But unfortunately, if I do it, I've got to follow the list. So whoever's next on the list, I've got to appoint. You're far better off if you can agree on someone who you both had confidence in as a fair and competent facilitator. And I'm willing to give you, I know it's hard getting into the good facilitators, but I'm going to take a shot at having you complete it within 60 days. If you're having trouble getting in within that time period, just let me know, or you can do a stipulation. But I think sooner rather than later, I understand the frustration here with how long this process has dragged out. I've had no small part in how long this matter has dragged out. And I would be hopeful that it would be resolved. If not, we'll get you a hearing date as soon as we can. The hearing will include the issue of attorney fees. When attorney fees are objected to as to amount or reasonableness, the law is pretty clear. I've got to conduct a hearing. I've got to take testimony on that. I can tell you that what has been presented appears to be reasonable, both in terms of amount of time and hourly rate. But without agreement to that, I don't have any choice. I've got to include that within my evidentiary hearing.
And I will say on that issue, I only have a handful of the invoices from Mr. Rick, but what I've seen, and I told Mr. Kelly this, I think it's reasonable. I think the rate was reasonable. I actually thought the rate was quite a bit less than I thought it was going to be. But I only have maybe 3 or 4 invoices, so.
We may be able to resolve that issue, Your Honor. I have some billing statements from prior counsel, and so I don't have any objection to those. They're only primarily as to the trust and not the estate, and he's claimed $3,200 in attorney fees on the estate, and I haven't really seen documentation of more than $500. But I think we may be able to work through that issue.
I think so too.
Yeah. So, Your Honor, just so we're doing things, covering all the bases here, I think all we've technically talked about so far is the estate.
Yes.
Did you want to talk about the trust as well?
Sure, but I would be including that within the whole, I would hope that everything gets facilitated.
Sure, and so, we did file a separate petition actually a separate motion on your opinion and order regarding objections to the account of fiduciary, and we did also file an amended petition, which the court invited us to do in its opinion. And so I would like to get a ruling on that as well, on a motion, maybe perhaps allowing the amended petition. I'll just say on the issue of the trust generally, Mr. McCord is apparently asking for that to be relitigated entirely. He wants to have, further scheduling order and evidence and an evidentiary hearing on things we've already taken on. I don't think there's any need for further discovery or evidentiary hearings on this other than potentially with respect to attorney's fees. And so I guess I would object to the extent the court might allow proceedings to continue a hearing on attorney fees.
That was certainly my intent when I issued the opinion that I was resolving, addressing, ruling upon all pending issues in the trust itself. I'm going to grant the filing of the amended petition. The fact that I invited it, I think I effectively granted it when I issued that opinion, but if another order is necessary, I'm happy to sign it.
Right. And just for the record, Judge, we did file a response to that amended petition simultaneously with our responses to the motion, so.
Okay, so at least in terms of housekeeping today, is there any other order the court needs to issue other than reopening the estate, allowing the amended petition, and scheduling the matter for facilitation by a facilitator of the choice, of the party's choice, of all issues in the estate and the trust within 60 days?
My clients have one other kind of housekeeping concern that they asked me to talk with the court about. The court has an existing order that directs Mr. Kelly to retain the proceeds from the sale of the house in an account and not distribute it to anyone. And so we recently confirmed that Mr. Kelly does have a TD Ameritrade account that includes the value of the proceeds plus another $5,000 roughly. I don't know if it's a trust account or if it's Mr. Kelly's personal account. The statement I received doesn't show that. My clients are just concerned that perhaps it would be best if those funds were held by a third party in escrow rather than in an account that Mr. Kelly controls. And I suspect that we could probably approach American Title and they would agree to hold those funds in escrow rather than having them just at Mr. Kelly's control.
Well, the difficulty with holding an escrow is there's no opportunity for a return on those. It just sits, and I don't like that. We could put an order in place directed to the entity with which that account exists, ordering that there be no distributions from it without approval of the court. And I'm assuming wherever the account is held would honor that order.
Yes, that is TD Ameritrade is where the funds are held.
I think that's the easiest way to do it. Just make sure they get a copy of the order that there be no distributions from this account without further order of the court.
Okay, well, there is, as I said, an existing order that prohibits Mr. Kelly from distributing anything. I suspect if I just shared that order with TD Ameritrade, maybe that's enough.
And if it's not, just come back, or if the two of you can stipulate to something, you know my intent.
Right.
I don't want Mr. Kelly to be able to
We would
loot the
stipulate,
estate.
we would stipulate to that, or whatever TD Ameritrade needed to make that happen.
I think that's far better than sticking it in a non-interest bearing escrow account.
Very well, Your Honor.
Okay, anything else today, gentlemen?
No, Your Honor, thank you.
All right, if you're unsuccessful in your facilitation, notify the court. We'll get hearing scheduled, and I will do my very best to expedite from this point forward.
Thank you, Your Honor.
Thank you, gentlemen. Have a good day.
Your Honor, thank you, Mr. Rick.